Hello everybody and welcome back to VirtualCon 2014 and our 4 p.m. presentation for today, Crowdfunding Strategies, with our host, Greg Piccionelli. Mr. Piccionelli, how are you doing?
Hey, I'm pretty good. Thank you again for inviting me. It's wonderful to be here virtually, of course.
Not a problem. It's always a pleasure to have you. So Greg, without further ado, I'm just going to hand you the floor.
Oh, great. Okay. Well, good afternoon, everyone. It's good to be back. I don't know what number other verse presentation this is for me, but I rather enjoy it. I am Greg Piccionelli. My law firm is Piccionelli and Sarno, of which I'm one of the founders. My practice areas include internet law and entertainment law, including adult entertainment matters of all sorts. Many of you may know me as the longtime legal writer for XBiz. In fact, I am its first and now longest legal contributor. I've had a monthly column for the last 10 years in XBiz, writing on every legal topic of the day, I believe, for the last decade. I personally focus on legal matters in my practice that pertain to business transactions and litigation pertaining to the protection, exploitation, and enforcement of intellectual property rights. I also am a free speech advocate, and my practice also involves issues that are involved in the protection of free speech and expressive rights. And in my career as a legal advocate for free speech, I've been responsible alone or with other attorneys for a number of changes in the law that have helped to protect our free speech rights and have, in the process, tremendously helped adult entrepreneurs. One of these, of course, was the change of community standards for internet distributed content from a local community standard to a national standard, at least in the Ninth Circuit. I'm also a patent attorney. I'm pretty sure that I'm the only one that is also doing adult entertainment law, and I'm an inventor now with over 50 issued patents and counting. But enough about me. And now let's go to today's very important topic. I'm going to be talking about crowdfunding and what may be a game-changing U.S. law that was passed in 2012 that will hopefully go into effect sometime by the end of this year or in early 2015. The law that I'll be referring to is the crowdfunding section, or Title III, of the Jumpstart Our Business Startups Act of 2012, which is often referred to as the Jobs Act. So I will be referring to Title III, or the crowdfunding provisions, or of the Jobs Act or the Crowdfunding Act when we talk about that law. I believe it is going to be a game changer. If it's effectively implemented, it has the potential, I think, to revolutionize the way small businesses get capitalized, and also how small businesses can acquire additional capital for expansion and for new projects. It could, in fact, I think, revolutionize capital formation literally on a global basis. And this is in large part because of the importance of the United States globally, but also how the world views business in the United States and American entrepreneurship. What the law does, in essence, and I'll go into it in a little bit greater detail later on in this presentation, but what it does basically is it lifts long-standing prohibitions on advertising and the sale of stock that has been in place since the days of the Great Depression. In doing so, for the first time, the full marketing power and global reach of the internet can at last be used and brought to bear by non-public companies to raise capital and fund projects by the selling of stock and the issuing of other securities. The law is really a whole set of new regulations that are now promulgated by the SEC, and they run some nearly 600 pages, which was really a bear to get through. It's the driest reading you can possibly imagine. And also because of the voluminous nature of these regulations, of course, we're not going to be able to get through all of it, or even the very tip of it, really. But I'm hoping to give you at least some of the outlines and contours of the act and why it's going to be really important. But before we address some of the important provisions of the new law, I believe a little bit about crowdfunding and how the law came into existence is going to be helpful. For those unfamiliar with what crowdfunding is, it is, in general, a method of raising capital for a project or a venture or an enterprise through the pooling of numerous and usually relatively small financial contributions or investments from the public, usually via the internet, with the hopes of accumulating through all these small little investments and donations a large amount of capital. Generally, there are two types of crowdfunding: donation-based crowdfunding and equity-based crowdfunding. Donation-based crowdfunding is often referred to as gift-based crowdfunding. In this type of crowdfunding, money is raised through donation. Basically, people beg for money is really what it comes down to. No stock is sold, and there's no exchange of capital for a share of an ownership in a company or a venture. A money donation or contribution, therefore, by someone in a gift-based crowdfunding circumstance does not result in any ownership in the company or any entitlement to any share of the profits or any monetary payback in the future. The other type of crowdfunding, which is referred to as equity-based crowdfunding, is like gift-based crowdfunding. It's also attempts to aggregate capital through a large number of small contributions. But unlike gift-based or donation-based crowdfunding, the persons contributing to the capital actually do obtain an interest in the venture or the company. Essentially, they're going to get a piece of the action. Now, gift-based crowdfunding has been around for a while. A while means a few years, but that's sort of an eternity in internet years. This type of crowdfunding has been successfully used through online platforms such as Kickstarter or Indiegogo. You can go and visit those at Kickstarter.com and Indiegogo.com. Those are probably the two best known ones right now, but there are now over 100 donation types of crowdfunding ventures or what are called portals on the web. These are places where people go to potentially participate in donation-based or gift-based crowdfunding. Over the last several years, these online portals have provided services that have helped literally thousands of companies and individuals to fund businesses and to fund their projects. These are the places at which people basically do their pitch for the donation. Kickstarter, which is perhaps the best known and certainly the most successful crowdfunding portal, rose to prominence originally focusing on creative projects, usually independent film projects and music projects. And while we're on the topic of independent film projects, here is my opportunity to shamelessly provide you with a promo or a pitch for a venture that I'm affiliated with, which is an online social network directed to independent film and other types of film projects. The name of it is Stage 32, and that can be accessed online at stage32.com. We currently have about 350,000 members, and it's a pretty cool site for independent film producers and parties involved with independent production. And I know a lot of the people listening here are motion picture producers, so it's a good place for you to check out. It's pretty cool. But it also has another nexus to what I'm talking about, and that is that many of our members at Stage 32 have used Stage 32, this broad social network, to help them with their donation-based crowdfunding. And since we're now back on crowdfunding through this slick transition, we're going to continue talking about Kickstarter, our famous and perhaps most successful donation-based platform. And it has that appellation, I think, rightfully so, because of what it has accomplished in such a short period of time. In the field of motion pictures, Kickstarter, for example, has raised over $100 million for film projects. And that's, pretty amazing when you consider that $100 million have been raised without any right or expectation of sharing in the profits of a movie if it's successful. Also pretty amazing about Kickstarter at this point are the statistics associated with how successful these movies have been. Over 100 of them have now, well over 100, I think they're now approaching almost 200, have been released theatrically. To date, 6 have become Oscar nominees. One of them, a movie called Inocente, won last year's Oscar for Best Documentary Short. And for the last 4 years, the Kickstarter-funded films have comprised at least 10% of Sundance Festival's independent films. And that's very important. For those who know independent film, Sundance is a pretty big deal. But what has really been an amazing part of the story for Kickstarter and for crowdfunding in general is how donation-based crowdfunding projects have been used to finance projects other than motion picture and music projects. Because of the success of funding motion pictures and music projects, it's not surprising that quickly what started to happen is people wanted to fund their other ventures through donation-based or gift-based crowdfunding in a likewise fashion. And certainly that began to happen with Kickstarter way back in about 2010, I believe. And here are a few of the mega success stories. The first I want to share with you is a company called TikTok. In 2010, a Chicago designer by the name of Scott Wilson made history as being the most successful Kickstarter campaign up until that time. His creation, this thing called the TikTok, followed quickly by a creation called a Lunatic, were both wristbands that converted an Apple iPod Nano into a wristwatch. His Kickstarter campaign attracted over 13,000 backers. He had originally asked for $15,000 in crowdfunding funds, but his campaign quickly raised over $900,000. And he got to keep the money. I mean, whatever was raised, he was able to keep. With this initial success, his company was able to sell his TikTok and Lunatic products in major retailers like Walmart and even at Apple stores. And his donors contributed an average of about $25, and in exchange, what they got as a gift from his company in exchange for the donation was one of the wristbands, which retailed, at least initially, for about $40. But TikTok was not the only watch that made it big on Kickstarter. Soon after his Mr. Wilson's TikTok wristband, a company called Pebble Paper provided or launched their Kickstarter campaign for a product, a watch as well, and that campaign blew away the TikTok campaign. The Pebble Paper campaign attracted nearly 70,000 backers and raised a whopping $10 million, far surpassing its goal, which was $100,000. And what was amazing about that campaign, I recall, was that it raised $1 million in donation in the first 28 hours on Kickstarter. That's staggering. But it's nowhere near as staggering as the next success story, which I believe really gets the grand prize for crowdfunding, at least so far. That goes to a company that should be of great interest to everyone listening to me. That company would, of course, be Oculus Rift. That company has, that's the company, for those that don't know, is the company that's developing an immersive virtual reality headset, which is really quite cool. In mid-2012, Oculus Rift sought to raise $250,000 through a crowdfunding campaign on Kickstarter. Like the other mega successful ones, it quickly raised more money than it originally had sought, and by the end of the campaign in August of 2012, the company had 9,522 backers who pledged a total of $2,437,429. An extraordinarily successful crowdfunding campaign by anyone's measure. But what happens next is completely off the charts. In March of this year, 1 year and 7 months after the end of its crowdfunding campaign, Facebook bought Oculus Rift for $2 billion. Well, I think this whole story is just nothing less than simply amazing. It's unprecedented, and it is game-changing, in my opinion. Think about it. A crowd-funded company that sold for more than $2 billion in little over a year and a half after its original crowdfunding. It's mind-blowing. It just is amazing to me. And clearly it says something about the power of crowdfunding and the ability of crowdfunding to help those with fresh ideas, to help them get funded to make their ideas a reality. The story also says a lot, I think, about the perception of the future of virtual reality and, by extension, virtual worlds. So dare I say it, I think because of the Oculus story, crowdfunding and virtual world products and services, I think, have a very, very bright future together. And that, of course, is the reason why we're here. One of the things that I think has helped to make gift-based crowdfunding so successful has been, of course, the gift. That comes in association with donation-based crowdfunding, or at least typically has so far. This is often referred to as the reward. Typically, a person donating, say, $25 is rewarded with either a copy of the product or a unit of the product that is sought to be produced. For example, if the money is being sought for a musician, songwriter to create a CD, the reward is going to be a copy of the CD. If it's an independent film producer, often it is a copy of the DVD. Larger donations often, at least traditionally, have garnered like a mention in the liner notes of a CD, or possibly even a credit associated with the movie project. But the reward can also be a unit of the product that the entrepreneur is seeking to produce with the funds that are being raised through the crowdfunding campaign. For example, as I said earlier, with respect to TikTok, its donors were provided with an actual copy or an actual unit of the wristband. In this way, you might want to think of the reward as kind of a pre-sale. At least I do. It's kind of a pre-order mechanism, I think, because the parties that contributed to the TikTok campaign were able to get, for say their $25 donation, a wristband that when it came out sold for $40 or $40 plus in some instances. But other than the reward, I think it's important to understand with gift-based or donation-based crowdfunding that there is often also a significant emotional component. There is what I call the good deed or a mensch factor of being able to donate to someone that a person feels is worthy to obtain a donation to do something creative or laudable or contributory. Also, crowdfunding platforms like Kickstarter, you have those that are, for example, more or at least traditionally oriented toward creative projects, have shown that that crowdfunding can actually connect people with the artistic or entrepreneurial process itself. Many persons actually enjoy being a mini sponsor or a mini benefactor for talent, sort of a new age Medici, if you will, or mini Medici, as I've said. So this enables crowdfunding donors or supporters to become early supporters of an artist that they believe in. And strangely enough, but I think it's a good thing, that in many instances has been thrilling enough for many investors to donate money. But now let's shift gears a bit. So far, we've been talking about donation-based crowdfunding. And that's the type, once again, that does not provide the person donating the money with any stock or any right to any reward that results from the company producing the product or turning a profit. On the other hand, the other type of crowdfunding, equity-based crowdfunding, does entitle investors to an ownership interest in the company or a share of the profits. And this, to quote Alex Trebek, is like the double jeopardy round where the scores can really change. The only problem is that to date, equity-based crowdfunding has not seen the same kind of success as donation-based crowdfunding. And so many people believe that it is not really going to be big. Well, there's a reason why, to date, it hasn't been able to compete dollar-wise or success-wise with the gift-based or donation-based counterpart. This is because equity-based crowdfunding has been illegal in the United States. That is, until now. Let me explain. Prior to the time of the Great Depression, just about anyone could advertise and sell stock in a private company to just about anybody. And in fact, that did happen. There was a lot of fraud, particularly in the 1920s. In the roaring 20s, there was a booming economy, and that led to a booming stock market and a lot of instant millionaires. So the average Joes and Janes of the time, heard that people were making money in the stock market, and understandably, they wanted a piece of that pie too. So when these folks were offered a chance to buy stock, usually that offer was associated with some kind of get-rich-quick story, these folks often jumped at the opportunity. But unfortunately, the stock and the story were usually provided to them by unscrupulous hucksters, and the result was that a lot of people lost a lot of money in so-called pie-in-the-sky or blue-sky ventures. Often people, unfortunately, invested their life savings in companies that didn't exist or were just unlikely to be profitable or even stay in business for very long. Many bought a piece, for example, of a fictitious gold mine or a fictitious oil field. Some literally bought stock in worthless swampland, and some literally bought shares of the Brooklyn Bridge, and those were the unfortunate origins of those phrases. But what was really sad was that these huge economic losses from all of this fraudulent stock sale activity was one of the aggravating aspects of the problems of the Great Depression, because a lot of people's net worth went to zero. They lost their life savings. It just made the problems of the Great Depression all that much worse. It's interesting, just a side note here, how history often repeats itself. We had this big economic boom in the roaring 20s, like the economic boom of the early 2000s. And what resulted was a booming stock market and a lot of people that wanted in. They wanted to be making money like so many people they saw making money. And in the early 2000s, and through the boom of the early 2000s, there were a lot of hucksters like Bernie Madoff with Ponzi schemes and other great get rich schemes. And unfortunately, it ended in the 2000s with crash in 2008 and a lot of these schemes falling apart, just like they did after the Roaring '20s. And it's unfortunate how it looks like human nature just recapitulates itself, and with this greed and fear cycle. And unfortunately, I think what happened in the early 2000s, there was again the lure or greed factor for easy riches, and the fear of being left out, and unfortunately people like Madoff and others out there preyed on that, and once again a lot of people lost their life savings. And the unfortunate reality is, just like the boom of the Roaring '20s, we had, which resulted in the bust of the stock market in '29 and the Great Depression, we had a bust in the stock market again. The stock market crash of '08 and the Great Recession, of which we apparently are now only coming out of. But even though these kinds of cycles repeat themselves, you can trust that our government is going to get involved one way or another. And the way they got involved in the '30s, I think, laudably to some degree, was that they enacted a bunch of laws to criminalize the fraudulent sale of stock, and in fact the sale of stock itself was tremendously regulated under the Securities Acts that were promulgated and passed in 1933 and 1934. In those laws, Congress sought to protect and against the fraudulent sale of securities by regulating the advertising and sale of all securities, which covered stocks and bonds and indebtedness and things of that nature. And soon after that, most states did the same. They passed what were called blue sky laws. So almost every state in the country has its own regulatory types of laws that regulate the sale of stock and security. Without going into great detail about these laws, the important thing to remember is that what they had in common was that they regulated how a stock offering could be made, how it could be advertised. And the idea was to essentially prevent such advertising and sale to average people, because these laws also had exceptions for what were called high net worth people, people who made a lot of money and who had high net worths, so that either they could withstand a loss of an unscrupulous or fraudulent stock sale, or they should know better because of their experience. So in this process of regulating the sales of securities, a big part of the regulatory system was how stocks could not be generally advertised. And this is one of the reasons why private stock is not easily, or has not easily been advertisable, at least through the United States, over the internet. Of course, that is until now. And that is the genesis, in essence, of the regulations that ultimately have led to the Title III provisions of the Crowdfunding Act. Because the success of the donation-based crowdfunding that we just talked about caught the attention of our legislators. Several members of Congress noted how much money was being generated by donation-based crowdfunding. And that led many of our lawmakers, also at the instigation of a lot of entrepreneurs and crowdfunding portal operators, to consider whether the securities laws that were enacted 80 years ago might no longer fit our times. Maybe those laws were too strict, and they were limiting companies' abilities to utilize new communication technologies like the internet and limiting their ability to raise capital. Lawmakers also in this process realized that if small businesses could be funded by donations tied to a promise of a small gift or a reward, then equity-based crowdfunding utilizing the web could literally be maybe a revolutionary or certainly a wonderful way that small businesses could acquire necessary capital. Lawmakers realized also this could be good for the U.S. economy. One of the most important reasons for this is tied to the fact that the United States is a magnet for capital from around the world. To understand this, one has to consider why the U.S. stock market has been such a successful magnet for world capital. First, it's because the United States has good rule of law, as it's said. Basically, we have a very well-developed legal system. And even though many people believe we have way too many laws and way too many lawyers, that legal system really provides for business a degree of certainty that is not available throughout the world. It's certainly the best legal system in the world, as much as we all complain about it and harp on it. In addition, we have stable politics in the United States, maybe too stable. A lot of us complain about the fact that what happens is the same politicians that make all the mistakes and create all the problems continue to get reelected. But that stability, nevertheless, is attractive to business. So between our stable politics and our very well-elaborated legal system, a lot of folks around the world feel that investing in the United States or United States companies is a better bet than investing in a lot of other places around the world. So lawmakers realizing that crowdfunding for small entities or entities that were not publicly traded should likely attract a huge amount of capital from around the world. And I think, in fact, that that is going to be the case. I mean, if you consider the fact that, let's say you're a person in a foreign country and you're thinking about investing money in a small business locally, where the political system may change, or in case of China, you've got the Chinese government as your partner, you may elect instead to invest in a small private entity in the United States. Say, instead of a beauty salon in Beijing, you may want to invest in a beauty salon in Beverly Hills. So in this environment in 2010, Congress was looking at how to maybe change the securities laws. And ultimately, in 2012, the government did ultimately enact the Jobs Act, which included Title III, which is the crowdfunding provisions. But even though this thing was elected was enacted 2 years ago, the Securities and Exchange Commission was required to promulgate rules. By the statute itself, Title III, the Securities and Exchange Commission had to come up with rules to basically effectuate the crowdfunding provisions of the Jobs Act. And government being what it is, that took a heck of a lot longer than anyone anticipated. Even though the law itself gave the Securities and Exchange Commission a certain time limit to do it by, they ultimately got around to doing it nearly 300 days late. But they eventually did promulgate the preliminary rules. They came out last October. Those preliminary rules were published for commentary by the public. That commentary period closed in February, and now we are waiting for the final rules, which hopefully, as I said, will come out by the end of this year or hopefully early in 2015. And we are off to the races for equity-based crowdfunding. The proposed regulations, as I said, are voluminous, nearly 600 pages, so I can't go into a great deal of detail. But as I said, I'm going to give you a few general contours to the law and things that you need to know to see if this might be something that your company might be able to take advantage of. So let's go into those specifics. The first and certainly one of the most important things to know about the Crowdfunding Act is that there are strict limits as to how much money can be raised each year through equity-based crowdfunding through Title III of the Jobs Act. The new law limits a crowdfunding raise to $1 million per year. And the proposed regulations now will allow the party seeking that money to establish basically a minimum and a maximum goal, if you will, for the crowdfunding raise for equity-based crowdfunding. The other thing that is important is, or one of the other things that are important to know about the Title III Jobs Act crowdfunding rules is that it will also limit how much investors can invest in a equity-based crowdfunding venture. Specifically under Title III, an investor cannot invest more than the greater of $2,000 or 5% of the investor's annual income or net worth per year. What that means is basically there's going to be a $2,000 limit, adjustable if the person has a greater net worth, but generally I think it's kind of good to conceptualize this as a $2,000 limit. If the party has an annual income or net worth greater than $100,000, this changes. This will allow that party to invest up to 10% of their net worth or $100,000 per year in equity-based crowdfunding. Now, what may come to mind here is how is someone going to keep track of how much an investor has already invested in other crowdfunding ventures, online crowdfunding equity-based ventures, when they come to invest in yours. This was one of the great concerns a lot of us had because it presented the possibility for the Securities and Exchange Commission to really muck up the works here. For example, if they put the onus on the crowdfunding entrepreneur to try to find out how much an investor invested in other maybe competing crowdfunding ventures during the last year, that could impose potentially some really severe limitations on the crowdfunding campaign, cost-wise, time-wise, etc. Fortunately, in the preliminary rules that were published by the SEC last October, the onus to determine how much has been invested falls on the investor, him or herself. And that's great. And hopefully it stays that way and the final rules will not alter that. Now, in addition to the monetary limitations, the two that we just said, that limit the total amount to $1 million or the total amount from each investor, which is $2,000 with some exceptions, as I've indicated, there's some other requirements. One is there has to be some background checks on the principals of the company, criminal background checks, that kind of thing. Also, there are going to be some requirements of filings with the SEC. There'll be an initial filing, and then there'll be annual filings with the SEC regarding the company. Also, the crowdfunding is going to have to be done through what's called a portal, which has a whole lot of regulations. That's probably the largest component of this nearly 600-page monstrosity that the SEC has promulgated. Most of those regulations are going to go toward the regulating the portals. Um, and so that is obviously the most complex part of the law, so I'm going to go into it very, very little. In fact, all I'm going to say about the portals are that under the regulations, the portals are going to be prohibited from providing financial advice. This means they're not going to be able to say that this particular crowdfunding offering is better than another, or provide any kind of financial advice regarding such crowdfunding campaigns. And this, I think, is going to possibly turn out to be a problem, because one of the reasons why the SEC has taken so long in promulgating these rules, or at least this is what they've said, and what some of the opposition to Title III was in Congress, is concern, again, that people are going to get ripped off. And if the portal cannot provide any advice or mechanism for evaluating a crowdfunding opportunity, then the public may be ill-served by this. There may be more fraud and more problems than would otherwise have occurred if there was some kind of a evaluative mechanism. And unfortunately, that could lead to a round of tightening of the regulations and a disabling or even destruction of the benefits of equity-based crowdfunding. So hopefully that won't happen, but nevertheless, I see this as being a possible vulnerability and some ill-advised regulation by the SEC. Another part of the law that I think is important to share with you are some of the costs that are associated with these regulations that are going to be put in place. The first cost is going to be that associated with the filing of Form C, which is the name of the form that gets this whole process going. The SEC has estimated that the costs associated with filing this initial form for crowdfunding will be about $6,000. Then there is an annual form, the Form-AR, C-AR, which the SEC believes will cost about $4,000 per year. Then in addition to these forms, when the crowdfunding campaign gets started, the filing also has to include certain types of either a formal audit or a CPA opinion, depending on the size of the raise. A formal audit is required for crowdfunding raises between $500,000 and $1 million. Those types of audits can be very expensive. They can range from $5,000 to $100,000, or even more in some instances if the company is very complex and the audit is quite elaborated. For raises between $100,000 and $500,000, what's required is a CPA review. Those reviews can be costly, but not nearly as costly as a formal audit. In my experience, such reviews generally can be between $5,000 and $10,000. What is interesting, though, is that seeing these costs, that these costs are going to occur, a number of entrepreneurs have been preparing to provide services to entities seeking crowdfunding, equity-based crowdfunding, so that these audits and reviews can be obtained for, say, less than $7,500. One of these companies is Crowdfund CPA, which you can get to at crowdfundcpa.com. Kind of an interesting way the system is already addressing what is going to be some significant costs associated with equity-based crowdfunding. But also interesting, I think, is the fact that there is no audit or CPA review requirement for raises under $100,000. I think this makes small capital raises for smaller projects requiring under $100,000 to be pretty efficient. And that's exciting news, and I hope, again, that the SEC does not change its preliminary rules to regulate these sub-$100,000 crowdfund raises by requiring any kind of audit or CPA review for those. Another cost that one has to consider is the cost associated with the acquisition of the background checks that I had indicated before, the criminal background checks, which will have to be performed on officers and directors and certain specified shareholders. While this is not a huge cost, it will range depending on the number of officers, obviously, and directors there are in the company. They could range from several hundred to several $1,000s. It is also one of those costs that you have to factor into the total cost for the acquisition of the required or requested capital. Finally, another cost that has to be considered is not one that is mandated by the law itself or the rules promulgated by the SEC. And that is going to be how much do you have to pay the portal as a commission for running your and making available your crowdfunding campaign. The estimates now are these are probably going to be somewhere between 15 and 20%. So one has to calculate all these various costs to get the ultimate efficiency of the equity raise that you want to do, because you're going to be giving up equity for this amount of money. But regardless of the fact that there's going to be these costs, many who have evaluated the situation believe that the system is workable and that these costs are going to be within the realm of doability. Actually, very much doable, especially considering that there does not seem to be, at least at the present time, anything that stops someone from simultaneously doing a gift-based a crowdfunding campaign, either in tandem or sequentially with or simultaneously with one that is going to be raising money through crowdfunding in exchange for equity. Consequently, I expect to see for some companies a donation-based crowdfunding campaign to raise capital to conduct the equity-based campaign, basically to generate the money to pay for the costs associated with the equity-based one. So, when we look at all of this together, I think, in conclusion and summing up here, I think what we are going to see, because of the entry of equity-based crowdfunding on top of what has been, quite frankly, a successful new phenomenon, gift-based crowdfunding, what we're going to be seeing is an exciting new way to raise capital. And as businesses are seemingly being generated with smaller and smaller economic units around the world, I think that this is going to be a major way of generating business for new companies that are just too small to generate any interest by banks or other angel financing, any number of traditional ways of raising money that just doesn't work when you're dealing with a micro company. Our firm now provides, in addition to business consulting and legal education for startups, we are now ourselves also providing counseling, both legal and educational, regarding crowdfunding. We are currently providing a pretty broad spectrum of clients information regarding crowdfunding in anticipation of the Jobs Act Title III going into effect in the very near future. we're working a lot with people who produce, as you would imagine, mainstream content, social media companies, computer game companies, app creation companies, companies that are doing technological development, one of which is a virtual world project, and a broad spectrum of other types of businesses, including adult businesses, which we've been engaged to provide crowdfunding counseling for two of them in anticipation of Title III going into effect. And so while equity-based crowdfunding is in its infancy, I do believe that it will soon become a major method of capital formation for many companies. So if you're interested in crowdfunding a project or a business under the Jobs Act and or a donation-based crowdfunding campaign, I want to tell you, you're well advised to consult with an attorney, particularly regarding crowdfunding under the Jobs Act. I've written several articles regarding crowdfunding. They can be accessed at xbiz.com, or please feel free to contact me at greg@piccionellisarno.com. I'll get you copies of the articles. And of course, if you are interested in additional information regarding crowdfunding or representation regarding a crowdfunding project, please feel free to contact me at 818-201-3955. Thank you very much. That's going to be the end of my presentation. Thank you once again to everyone at Otherverse, and I look forward to my next time with you.
Thank you very much, Greg, for that enlightening and well-informed presentation on crowdfunding strategies. We really appreciate having you again here, yet again. You're here time and time again, giving us wonderful presentations, so thank you very much.
Thank you.
So that concludes our last presentation for today in the lecture hall. Tomorrow we've got a big lineup of things happening. I know we still have another presentation happening in the studio hall coming up, so a lot more exciting stuff coming your way. This is a very special VirtualCon with the focus on VR, the focus on crowdfunding, so a lot of really cool and innovative ideas and information being passed around. Once again, thank you very much, Greg, for being here, and we will see you at the next event.
Thank you. Take care.